Welcome everyone to the Wednesday morning series. We have a special edition today. My colleague and our COO for Seeking Integrity Residential Treatment Program and all of the many offerings that we have, Stuart Leviton, who also is an attorney, is joining today. So we started in May. We had Kristen Snowden's Should I Stay or Should I Go? And then Debbie Allen had two partners, one stayed, one left. And then Deborah Doak did, kind of mediation, navigating the space. And I asked Stuart if he would bring his expertise. He also, let me caveat that, and he can tell you more, but he also went back to school, and he is a mental health professional now. So he can actually bridge, all of this. But today I'm looking to how do you navigate, kind of the legal world. So this is part of that series, and he's got a presentation. And for those of you joining live, we would welcome your questions in the Q&A at the bottom of the screen. So Stuart, I'm going to turn it over to you, and I will help navigate the questions, but I'm going to turn it over to you. You can share anything about yourself and your work that you would like.
Great. Thank you, Tammy. As always, great work, and we are greatly appreciative of all that you're doing for us at Seeking Integrity and for all the people you're helping. It makes a difference, so thank you. Welcome, everyone. It's great to at least see that we have a lot of people here who are interested in this topic of legal considerations when facing a relationship crossroads. A couple of prefatory remarks, if I may, and then we'll jump in. And I hope to share a few thoughts initially, and then the bulk of the time will be for questions and answers. By way of introduction, as Tammy has said, I am both an attorney and a registered associate professional clinical counselor, both in the state of California. I've been an attorney for 30 plus years, have done a lot of it. And I do not specialize in family law, although I have done some. And so I do not hold myself out as an expert. Even if I were an expert in family law in California, that doesn't mean I'm an expert in wherever you're dialing in from or zooming in from. On the clinical counselor front, that's really in the past 5 years that I've been doing that work. And I do hope to infuse this discussion a little bit about what both the strengths and the limits of what the law can do and where clinical counselors or therapists might come in. By way of a disclaimer, as Tammy has also said, I'm not providing legal advice today. I do that as a legal requirement. I can't do it this way. And importantly, you're not my clients. And most importantly, for anyone outside of California, you're in a jurisdiction that is different from the one that I practice at. I'm only licensed in California. And most of the family law, most of the considerations we're going to talk about today are governed by state law. So for those of you in the United States, that means we have 50 states. Each one has a different system. There are similarities, and so we'll talk about it conceptually, what some of the considerations are, but they are different, and you really do need to get an expert in your state. For those of you who are international or outside the United States, there are also systems in place. The considerations we're going to talk about today will be generally applicable, but we cannot give you specific answers to specific questions because I just don't know. So I want to focus on really 4 areas as sort of highlights, and then we'll get into some questions and answers. First, I want to talk about why should you contact a lawyer, or why should you begin to engage the legal process when you're facing a relationship crossroads, so the why question. Then I want to move to the what question. What can a lawyer or what can the legal process do for you? And most importantly, what it can't. I want to talk a little bit about timing. When should you reach out to the legal system or a lawyer? And when perhaps it's not appropriate or not most helpful or effective. And then we'll do some general considerations at the end and then open it up for questions. Why? I start with the why because often if we understand why we're doing something, both what we can achieve and what we can't achieve, it will help guide the rest of this discussion. Why contact a lawyer? In my experience as a lawyer, people call me for 2 reasons, generally. One is factual. I want to find out what my rights are. Like, what does the law have to say? the law has something to say about most of the issues that you're concerned about. It may not be what you want or like, but the law will have an answer, or some judge will have an answer. And so if you cannot agree with your spouse or partner about these things, then the law will fill it in, or a judge will fill it in. Importantly, the law will also fill in the rights of your spouse or partner. This isn't a one-sided thing. If this is a relationship of two people, both of you have rights, both of you have responsibilities, and the law provides a default, and it may be helpful to know what that default is if you can't agree otherwise. In most jurisdictions, you can agree otherwise, and I encourage you to do that. But if you can't, the law will fill it in. For example, in California, we're a community property state, and so community property is divided 50-50. That's the way the law is. There can be huge discussions about what property is community or not, what the value is, how do we divide it. It's not as simple as just let's split everything 50-50, but the default construct, the system is there. So why contact a lawyer? Factual. I want to know what's going on. And you may also contact a lawyer for advocacy. You may want to pursue claims. You may need to defend against claims. And so factually, either knowledge or advocacy, perfectly appropriate. Why else do people contact lawyers? Usually it's about feelings and emotions. I'm feeling angry. I'm feeling fearful. I'm feeling resentful. I'm feeling frustrated. I want revenge. I want to inflict pain on him or her for what they have done to me. And feelings and emotions. Lawyers are terrible at dealing with feelings and emotions, at least in my experience. We try to be empathetic, but I'll tell you, I am a far more effective lawyer today, having done the clinical counseling work that I've done over the past number of years. So much of the stuff I wouldn't have even known as a lawyer, even this difference between fact and feeling. If I were giving this lecture or this presentation 5 years ago, before I did the clinical counseling work, I wouldn't have even talked about feelings and emotions. It wouldn't have even come up. And so I don't want to knock my colleagues and who aren't necessarily the most sensitive to it, but the professionals who are lawyers and the system, the legal system, isn't very effective with facts, with feelings and emotions. Who should you turn to for those? Clinical counselors, therapists, psychologists, the mental health professionals who are trained to deal with that. So if your why is factual, great. If your why is emotional or feelings, I would ask you to question that why and redirect it to a mental health professional and not a lawyer. What can lawyers or the legal system do for you? When it comes to family law and when it comes to relationships, generally the law and lawyers are going to deal either with property, something economic, and how do we divide it up, whether it's real estate, whether it's personal property, whether it's income. It's something financial, it's something economic, it's something that has to be divided. And lawyers can deal with custody. If there are children involved or other dependents, could be adult children, could be parents. If there are dependents involved that need to be cared for in one way or another, the law will have a system about how we do that. So law, and it's decent. It's a good set of default rules. As I said before, if you don't like what the default rules are, you can always agree around them, or usually you can agree around them, and I encourage that. But that's what the law can do. What are the limitations of the law? What can the law not do? As I said before, under the why, terrible at addressing feelings and emotions. And in my experience, if anything, the law will exacerbate negative feelings and negative emotions, and it will actually make things worse, not better. Why is that? Well, our system isn't designed to take into account feelings. It's mostly an economic system. Or what I've heard from the family law judges that I've talked to is they said, why would you want a judge who's a complete stranger making decisions about your children? How could they possibly know what's in the best interest of your child? They don't know your child, and they will. And I've had family law judges who say, we make these decisions every day. We don't like to, but we will. if you can't make it for yourself. So I really encourage, figure this stuff out if you can. And don't allow the lawyer or the legal system to be the mechanism to address feelings or to address emotional conflict with the person that you're separating from, because it's just not very good. When should I call the lawyer, or when should I engage the legal system? In my view, if it's purely a factual, like what are my rights, and it is helpful to know what the default system is, you can do that early on. I know Dr. Rob Weiss often talks about AI and chat GPT. I actually looked at it this morning, like to see what it might say. And it's not a bad starting point if you just want to like, what are some basic rights? Go online, Dr. Google often provides a lot of advice, or even reach out to a lawyer, schedule a 1-hour consult and say, look, I'd just like to understand what's the baseline, what's the default, what are the basic rights that I might be facing or my spouse or partner might be facing. But what I would say is, if you're the betrayed spouse or the betrayed partner, and you've just had initial discovery or disclosure, pause. Don't turn to the lawyer. Turn to a counselor, a therapist, turn to a minister, a pastor, a priest, a rabbi, some clergy person, turn to support groups. Because the initial trauma that you're experiencing as a betrayed partner, the legal system can't really address. And if anything, I believe it will make it worse. And once you get over the initial shock, again, if you want to be grounded in like, what are my rights, so that I at least know them, do a consult, and then pause again. Put the legal process on pause, unless there's urgency. And of course, if there are child issues or custody issues, or if there are property issues that require immediate attention, give them whatever attention they need. And if it requires a lawyer, then go consult a lawyer. But I often say, on these highly emotional issues, and they're emotional on all sides and everyone involved, get the counseling, get the therapy, get the support that you need for the emotions so that you can begin to work through them. And then you can leave to the legal system that which the legal system is best at, which is dividing up property and deciding on custody. And that you can do some number of months into the process, but you will be better grounded and regulated emotionally to do that. And then the legal system will do what it's best at, and the mental health professionals and the mental health system will do what it is best at. Some other considerations to take into account. Time. The legal system is a time suck. It takes a lot of your time. It takes a lot of your emotional energy, and it is slow. Here in California, it's getting worse. Things are just taking an exceedingly long time to do. And so if you're going to wait for the legal system to catch up to you and to solve whatever the problem is, it's going to take a long time. The legal system is incredibly expensive. It is expensive for the lawyers. It's expensive for the experts who are going to be involved, if it's forensic accountants, or if it's psychologists or other mental health professionals, if we're doing evaluations of the children or the parents. There may be other professionals, there may be investigators involved. Man, it's just really, really expensive. And even if you're of the belief, well, my spouse is going to pay, or the court's going to allocate the cost to somebody else, the reality is the family unit only has so many resources. And unless you have unlimited resources, which some people do, those resources are going to be spent on people like me as a lawyer. And in my view, it's not going to get you that much further down the road, because again, the emotional pain, there's nothing I can do with. And I can get you the best settlement possible from an economic standpoint. And the reality is the trauma or the unhealed wounds are still going to be there. You might be in a really nice house. And I don't mean to make light of this, but the emotional trauma, the emotional betrayal has to be addressed, and it can't be addressed through the legal system. And so I strongly encourage people not to expend huge amount of resources unless it's absolutely necessary for the core issues which the legal system can deal with, property and custody. The emotional stuff, do the work with mental health professionals that's required, that will give you the relief that you so rightly deserve and want. Lack of satisfactory resolutions. Man, at the end of the day, the law just isn't going to get you to where you want to be. Because again, so much it's about unsatisfactory resolutions and the lack of flexibility and adaptivity. The law is pretty rigid at times. It's a set of default rules. They will come up with a solution and they'll impose a solution on you, but it's highly unlikely it's what you want or maybe even need. And the law is pretty static, whereas life is dynamic. Things are changing, particularly if you have children. They're growing up, their needs are changing. And so you're either able to adapt on your own or you're going to be constantly back in court. And so then the cycle just continues again. It's expensive, it's time consuming, it's unsatisfactory, and it's not adaptable. I really encourage, I think if I had to have a takeaway, and then I'll stop and we'll open it up for some questions. If I had to have a takeaway, empower yourself with knowledge and understanding about what the law can do and cannot do. Understand why you're engaging with the law. And again, is it for things that it can actually help with or not? Deal with the emotional trauma or the emotions around separation appropriately with mental health professionals or other support groups, 12-step programs, wherever you're going to find the support, but not look to the law to do it. And if at all possible, set aside the personal so that when it comes to property or custody, you can come to some agreements with whomever it is that you're separating from. Property, we can separate. You can go your separate ways, although often we'll see family businesses or your kids are involved in this, that, or the other thing. And certainly if there's custody, you're never going to completely separate. You have children. You have things that will bind you together for life. So that more that you can figure out how to either co-parent or coexist without the anger, the bitterness, the frustration, the resentment, at least in the moment relating to those things, and address those absolutely legitimate emotions in a different venue, you'll be able to make progress. I have seen where people continue to use the law to try to address the emotional hurt. Almost always unsatisfactory. So why don't I pause there? That gives you a good sort of overview of my take on these things. And let's see what some questions are, and we'll try to give you some answers.
Well, I have 4 things that I noticed. So, and you actually you just mentioned the business, and I hear often that there's a family business or they're working together or whatever. Do you have an opinion on the layer of complexity that could possibly bring?
Oh, Tammy, do I have an opinion?
I have an opinion. I know I asked it exactly that way. So
I have an opinion on most everything. So forgive me, everyone.
I know Stuart well. That is the truth. So
yeah. When it comes to businesses, it adds another layer of complexity, because often if we have to separate a business, now we're not in family court. At least in California, we're back in civil court. And I have been involved where I'm the civil lawyer trying to deal with business issues, and we have the divorce lawyers in family court. And man, so you have multiples, doubles or triples the layer of professionals. And so it gets that much more expensive. And yeah, civil court, the rules about businesses are different. So for example, in family court, it's community property and we're going to divide it 50-50. In civil, we have fiduciary duties. So if you're the managing person of the business, not only does your spouse have a 50% interest in that business, but you owe them a fiduciary duty to not harm their ownership interests. And so now we're litigating not only what is the business worth and how do we divide it and how do we get fair, but are you running it correctly or incorrectly? Did you do that for your benefit or for my benefit? Man, it gets complicated. When there's businesses also valuation becomes a huge issue. How much is this thing worth? And of course, the person who's trying to hang on to it, it says, oh, it's worthless. And the person who wants to be paid out, oh, this thing is, the next, I don't know, Meta or Facebook or whatever it is. And so now we get valuation experts involved. It gets really complicated. Um, and at the end of the day, it's going to be unsatisfactory. And putting it on a judge who probably is an economist, probably most of these judges, at least in California, so many of them are prosecutors or criminal defense lawyers, and you're asking them to do sophisticated business work. They do the best they can. I give all credit to the colleagues who are on the bench. It's just really hard. So yes, I think it really takes a lot to rise above the personal when there's a business or there are other assets that are not either easily divided or easily valued.
So you mentioned, and I wrote down, therapists, like what is the goal of the legal? And I'm wondering, because you were talking about, we'll take a pause and kind of, like, what are you seeking? And I'm wondering how, so this is putting your other hat on, how well do you think therapists can help somebody navigate the emotion versus the legal, like help it be a container? You get what I'm trying to get to?
Yeah, I mean,
yes, thanks.
In the ideal world, the therapist and the lawyer would be working and not necessarily in tandem, but they would have consistent goals. I think for the therapist, the most important role is to try to ground a client and to try to help the client process the emotions, whether it's betrayal, whether it's resentment, anger, frustration, safety, fear, whatever these are. And to the extent possible, help the client understand what can the legal system, how much of this can the legal system address, and how much of this is not about the law at all. So if a client comes into me as a clinical counselor and says, I'm really afraid about my money, like I don't have any money, or my spouse controls all the money, well, that's something we may want to engage a lawyer on. Like, how do we protect your economics and make sure that you're going to have sufficient money to pay the house, pay the food, pay whatever it is? And those are very legitimate concerns. And if you're in a relationship where one person absolutely literally controls the checkbook and the other person doesn't have access, we need to, that fear is real. And that, go to a lawyer, figure out how do we make it, or go to your spouse or partner and come to some early agreement so that we can eliminate that. On the other hand, if the issue is betrayal trauma, how could this person have done this to me? That's 95% on the clinical counselor or the therapist to work through. And I would hope that the counselor would say, you know what, that's not a legal issue. And even once your divorce is final, we still have to work on this betrayal trauma. On the other extreme would be, just pure custody issues or something, or these financial issues. It's like, that's 95% legal. Go get a good lawyer to try to do it. So to the extent we can identify in which camp it sort of falls is helpful.
So you talked about fear. And so one of the things you said, kind of early on, but maybe not early on, really take a pause. But I find so many, particularly betrayed partners, are like fear. They don't have any information. They don't know what a divorce would look like, or even separation or whatever in their state. And so, I usually go get information. And, yes, ChatGPT may be, a good starting place, but with your unique circumstances and things, to me, it seems like getting a consultation, if you never take any, forward motion on that, but at least, because to me, knowledge is, if I have information, then I'm not going, well, I think it is this, or my friend said that,
I do think early, I wouldn't do it on the day of discovery or disclosure.
Correct.
I would pause a little bit. But I think a 1 hour consult or a couple of hours, or maybe a couple of sessions with the lawyer, it wouldn't surprise me if you did a 1 hour consult with a lawyer. The lawyer gives you some homework. You have to go investigate a few things, and then you do a circle back. I think that's all appropriate. To jump into a divorce proceeding or to jump into litigation at the very early stage, in my view, is not going to be helpful. unless you have a very strong, either there's a compelling reason to, there's an urgency to jump in, or you have an incredibly strong network around you, support system. So let's say you've been in counseling and therapy for a year or two. You've got a really solid therapist, you're working a program, you've got a support system. Then if you get to the decision of separation, you've already done a lot of that work. My concern for the people who jump in, right after discovery or disclosure, is it's going to be more emotion than legal, but you're turning to a lawyer or you're turning to the legal process to provide answers to the emotional. And so I would discourage that. But I would also say in the end, I would hope that if you sought a lawyer for an hour or two consult, they can give you the best guidance on what you should do. At the same time, though, absolutely reach out to a therapist, and hopefully the two professionals are going to be giving you consistent messages.
I'm going to save my last question because you have now a bunch, and you should be able to see them if you open up the Q&A at the bottom of the screen.
Okay.
So the first one, can you see that?
Yes.
Okay. We are considering hiring a CPA trained in divorce mediation to figure out a separation of assets. Complicated because 30 years of 401ks. Costs around $6,000. Not ready for divorce, but this seems like a good idea. Any thoughts?
Of
course you have thoughts. I love Stuart. Yeah.
I offer some thoughts and suggestions. So, in the broadest context, hiring experts to assist you, whomever those experts are, probably a good thing. And I, as much as Dr. Rob is into AI and online research, which I'm okay with, hiring real experts in person who not only know the law or know the rules or whatever is going to apply, but can then tailor them to your particular situation, I think is really good. So hiring experts, I'm supportive of. And if you have a CPA who can do the calculations and they know how to do them, then that's probably a good thing. Cost $6,000. In the abstract, I don't have an opinion as to whether that's a good investment or not. If the 401k is, $1 million or multi-million-dollar accounts, $6,000 to figure it out probably isn't a lot of money. If we're talking about $50,000, it's going to eat up, and that's just the CPA. That's just the financial expert. That's not the lawyers who are going to do it. So it's also hard to do this stuff piecemeal. And so if you're at the point where you're trying to figure it out, and you've done the emotional work and you think that you can actually focus on, here's the property, we're just trying to figure out what the division is, what a fair and equitable division is, I would say a lawyer probably should be driving this process, and the lawyer should be hiring the experts, or at least directing what kinds of experts are actually helpful or not. Because you may not know in your particular jurisdiction, do you even need an expert to do this? There may be rules that this is just how we do it, or there may be a computer program. In California, there are a number of computer programs that generate like support payments, basic assumptions that it tells you what the support payment is. So before you jump in and try to solve your own problem, I would have a lawyer help direct it.
Okay, the next question. I think an important point also is that the law doesn't particularly care in a divorce who's wrong. In New Jersey, for example, you can get an at-fault divorce, but it has nothing to do with the split of assets.
California is a no-fault state. Generally, fault isn't an issue, I think, in most jurisdictions. So if the betrayed spouse is saying, but look at what my spouse did, and they acted out in this way, that way, or whatever, generally that will have no implications, certainly on the property division. It is what it is. And even on custody issues, most states are what's in the best interest of the child. And the presumption is what's in the best interest of the child is presuming parental relationships with both parents, or however many parents are involved. And so, if you're going to fight over, look how horrible a person this person is, generally not fruitful. And generally the law doesn't care about it, unless there's a particular wrinkle about behavior, either action or inaction, that'll either impact children or would have some impact on the property division. On the property side, I can imagine, let's say if one spouse expended community assets in pursuit of, let's say, supporting an affair partner or something, there may be some reimbursement claims to the estate, or you may be able to get some of that money back, or there may be some allocation like that. Maybe, I don't know, you'd have to check on your jurisdiction. Even that may not have an impact. This is where a lawyer can give you factual information about what's relevant and what isn't.
Okay, the next one. Do you recommend that someone file on their own through the local courts if we are in a community property state and all children are adults and out of the house, with the exception of one at university?
Hard to say. I'm I've done a number of cases where it's cleanup on aisle 1, 2, 3, 4, 5, 6, 7 because someone's tried to do it themselves, or they went to someone who wasn't very effective. I would, at a minimum, probably recommend at least consulting with an attorney. If the expense is challenging, often clients can do a lot of work themselves and can make it simpler. The most important thing you can do is come to agreements with your spouse or partner about how we're going to do this. And it sounds like we had a mediator previously. I know in California, it is becoming popular where it's often lawyers or maybe retired judges who will act as a mediator. So they're not a lawyer for either side, but they try to help facilitate resolution. The more that you can agree to, the better it is. But I would have a lawyer document it. I probably wouldn't do it on my own. If the kids are adults, then arguably we don't have custody issue of minors, but they're still your children. And you're going to have to figure out how to do things, or the wedding is coming up, or the grandchild is coming up, and who's paying for what, and how's it going to be done? So these issues will still be present, but the law is actually not very effective at doing that.
Okay, the next one. Can you explain alimony? Also, do the laws of the state you're currently living in govern the separation, or the laws of the state you were married in?
So here's a great lawyerly answer. It depends. And most lawyers will start with it depends. So alimony, generally, we have two kinds of support. Generally, alimony is between the spouses, and usually the one who makes more money will have to pay some amount to the one who makes less money, income-wise. And then you have child support. And the two are different. In child support, if you have minor children, there are agreements as to how much each parent has to contribute to supporting the children. That's all governed by state law. Depending what jurisdiction you're in, may also govern whether you can file for divorce in the state you're currently living or not. There may be residency requirements to avoid what we call forum shopping, like I want to go to that state because that's more favorable to me. And some things may carry over. And so you really have to look, if you spend 40 years in a community property state, you move in the next, to a non-community property state and move and then file the next day, there are probably restrictions on trying to manipulate that. And so you really do have to consult with a professional, in my view, and the jurisdiction you're in to see what will apply. But it's a very good question to ask the professional.
So to add to this, if both partners are, of a significant means of their own, basically, if they're both earning a comparable amount, there's probably less likely to be alimony payments.
Correct. Generally,
okay.
if there is an equal, relatively equal incomes or relatively equal potential for income, then
okay.
the amount of alimony may be zero or little. At least in California, the length of if you're legally married. So I should say, at least in California, we have legal marriage. We have domestic partnerships, which are equivalent to marriage. And we also have what we call Marvin agreements, which we don't have common law marriage, but a Marvin agreement, for those of you who are old enough, after the actor Lee Marvin, if you'll recall him.
Oh, I remember this.
And
I'm old.
And in California, you can have an oral contract for support. And in that case, his partner said, I changed my life and he made promises to me. And so we evaluate that under contract law in California. And so in your state, it may or may not apply. So knowing, what's going on may matter. And yeah, after a certain, and also, at least in California, if you're married less than 10 years, the amount of support is different. If you're married more than 10 years, it could be potentially lifetime support for the spouses. And so it's not uncommon, people say the 7-year itch, 7, 8, 9 years. It's like if you're coming up on year 10 and you think you're in a rocky place, it's not uncommon that people will file before they hit the 10-year mark. And that's purely driven by the law.
Interesting.
I should also
Okay.
say,
Oh,
we haven't talked about prenuptial agreements or postnuptial agreements. Prenuptial agreement is just a contract. It's enforceable, I think, in most states. It's, we're going to agree up front what's going to happen in the event of divorce. I actually encourage them, not so much for the ultimate document, because the document's a contract. It's, can we flesh out what are some of the really hard issues, and can we manage our expectations? And here's the biggest point. If you can't, before you get married, and you identify this, and you truly can't work through it, then I would suggest maybe you shouldn't be getting married, because the issues aren't going to get easier. Once you're married and problems arise, it's only going to get harder. At least in California, post-nuptial agreements, agreements after you get married, are much more difficult to enter into, because it looks like it's maybe coercive, and we're concerned about people not being coerced into, particularly waiving rights. But you can contract around the marriage laws, like you can contract around most things.
so I know we've got questions, but I just have to ask. So when they're saying coerced, so like I hear of post-nup agreements where a betrayed partner is going, you need to sign this or I'm leaving. Would that be deemed coercion?
It depends. So
Okay.
in both at least in California, and all of this is what I'm aware of. You have to ask in whatever jurisdiction you are. Even prenuptial agreements, both sides need a lawyer. They need a different
Oh,
lawyer, and it
okay.
needs to be entered into at least a week before marriage. And this is to try to avoid coercion or undue influence or pressure. Post-nups are even worse. So it really takes it. You absolutely, you can do these yourself, but you should absolutely have lawyers on both sides, independent, separate, advising both sides, and meeting all the procedural requirements for them, as well as the substantive requirements. But yeah, the more uneven it looks, then the more likely a court after the fact will say there was some kind of undue influence or coercion and might void it.
So next question, I'm in a place where we are stuck in a neutral place where we're just living together. My wife goes back and forth on moving on and staying. It's been 13 months, but I will caveat that with it's only 13 months. I'm in a recovery and she is we take trips. I'm curious when enough is enough and just move on. I live in Washington.
So, so if you came to me as a lawyer, I would say, I'm going to switch my hat to a clinical counselor. This is a question for a clinical counselor, in my view. And I use clinical counselor and therapist interchangeably. And I probably should have said that up front. So my designation is as an associate professional clinical counselor. And there are also marriage and family therapists. They're licensed clinical social workers. I use therapist and clinical counselor interchangeably. They're the same thing, master's level clinicians. This is, I mean, man, this goes to the core of who you are and the core of where the relationship is at. And this is something that only you can answer. And I would say it is probably more important to work with a counselor or therapist to try to evaluate, what do you want? What do you need? Here's where, if you wanted a 1-hour consult with a lawyer, like, what are my rights? And so in California, data separation makes a difference. If I'm bumping up against 10 years, might make a difference. If I'm going to start a new job or a new business venture, there may be landmarks or guideposts along the way that you might want to take into consideration. But I would even argue, wearing back to my clinical counselor hat, if you're worried about all those economic things, I don't know, that's data. Maybe the relationship is over. I don't know. Or maybe you want to move on. If you're not concerned about the economic things and are really focused on the relationship, maybe that's where you should put your focus. As Tammy said, 13 months in the abstract could be a moment in time. It could be an eternity. my guess is there was stuff happening before the 13 months, and there'll be stuff happening as we go on. And so this is one of those where I think it's less legal and more clinical. And I would encourage you and support you in getting that help to help you figure it out.
And I'm going to quick tag on to that before we go to the next question. Yes, Dr. Rob talks often about, ambivalent love for partners, where I love you, I hate you, I want to move, I want to stay, like all of that. I would refer back to the Kristen Snowden May webinar, which is, I put the link for the webinars in the chat. There were 10 questions, and it was like, journal, each of you journal about those, and then work with a qualified professional to have a conversation. Some of it is, do I like this person? You traveled together, honestly, to me, this feels like some hope, because you guys are, doing life okay on some level. But yeah, getting more help to navigate those clinical issues, could be really useful. So, okay, Stuart, next one. We are planning to sell our home this spring. Is it better to involve a lawyer before or after the house is sold? I'm the betrayed partner. This feels like one of those time things that you were just talking about.
Well, so I guess this is a depends question as well. If you're selling it as part of a divorce, you may want to have a lawyer involved. I actually have a spouse that I'm working with now, where they're not divorcing per se, but they're definitely dividing up assets. And my client, actually, the house is in their name, and they're simply going to split the proceeds 50-50, which is what would be anyway. And so it seems to me it makes a lot of sense. But they're working with me on doing it as a lawyer, not as a counselor. And so almost, I never say never or always. But it's often, again, these are great questions depending on your jurisdiction and depending on your specific facts. It is worth a 1 hour consult or a half-hour consult with a lawyer to really pose the question, to get some good information, like what would happen and do I need? And I'm hopeful. Some lawyers, unfortunately, will say, well, of course you need a lawyer, and you need me for 10 hours, and here's a $5,000 retainer or a $10,000 retainer. It is what it is. But I think if in doubt, maybe here's a rule of thumb. If in doubt, I think it is probably better to go get a consult from either a lawyer or a therapist, so that you don't have regret. Man, had I just reached out and had I gotten it? And whatever the cost of that hour is, it is probably worth it to both get some factual information and to know that at least you have the information and don't have the regret. Wow, I wish I talked to a lawyer, and I wish I'd known, then what I know now.
Okay, so the next one, I am the betrayed, did a lot of emotional work over the course of almost 2 years, filed for divorce 2 weeks ago after false reconciliation that accumulated in an EMS engagement marriage seminar weekends after my husband decided to pursue the relationship with the affair partner, who I didn't even know was still in the picture. 2 questions. Can the cost of couples therapy be part of marital waste, since they always told him to end the affair and he said he would, but it turns out he never did? And second question, so skip down a couple. What custody schedule would you recommend for 2 children, 8 and 9? We are in Arizona and we have 50-50 custody, currently 2-2-3 schedule. Doesn't seem to be ideal, but maybe kids are still getting used to doing that. It's been 2 months. So start with question number 1 is the marital waste.
So this is going to be wholly unsatisfactory to you. I don't know, and I'm going to defer to the professionals involved. I don't know Arizona law, and so whether something constitutes marital waste or not, I don't know. I tend to doubt it, at least if it was couples therapy, simply because it didn't work, or simply one's lying. I doubt would rise to that level, but I don't know Arizona law. That would be something you'd have to consult with an attorney on. And then the custody issues. One of the reasons I don't do a lot of family law is custody. I don't have children. It is brutal. And the colleagues of mine who do it often will say it's the absolute hardest and most challenging piece of their work. And the family law that I have done has always been property only. I won't do custody cases. That I have great friends who do them and do them outstandingly. I simply won't handle them. I'm not prepared to do that. I don't have the expertise, but I'm not going to do it. And so the best thing that I can do, look, you're in pain and you're hurting, and I get that. And I completely respect it and will validate the pain. And this is one of those, again, the law is going to be unsatisfactory. This is something that I really encourage you and your ex or soon to be ex, try to work through to the best of your ability, get the counseling, the therapy, the support that you need to work through it. And ultimately, what's in the best interest of the kids? And I don't know your children at all. I don't know anything about them. But if both of you, if the two parents can truly say what is in the best interest of our children, which almost always is for parents to be getting along and at least collaborating and cooperating for the children, and to model the kind of relationship that you want your children to have, even in conflict, adversity, betrayal, that the children can be the focal point and not the cudgel or the sword or the shield. That's the ideal. And to me, the way to get there is a lot of clinical help, because we're not trained as people. We're not acculturated to do this. We don't have the tools. It's not an innate skill set. And so reach out for that help. And I think that's the best I can probably do at the moment.
And I would invite you, kids 8 and 9, they're all different emotional, templates and things like that. So I would encourage you to get clinical support for them and help them be able to have a voice in all of this as well, so they're feeling heard. But yeah, the co-parenting, especially when there's difficulties within the relationship, is challenging. But the kids, I agree with Stuart, need to come first. Does integrity abuse and the fact that the betrayed partners have the ability to make informed decisions removed from them factor into legal proceedings?
Let me just read this again. I'm not sure I understand it. Does integrity abuse and the fact that betrayed partners have had the ability to make informed decisions removed from them factor into the legal proceedings?
So one of the things that this feels, so we get lots of people that going, I want to tell the judge that he's a sex addict, and so it's along those lines of like, this is what he did and I didn't know it. So
I'm going to punt a little bit. And here's another, it depends. I don't know in your jurisdiction whether it matters or not. And this is probably where a legal professional, your lawyer, is going to be able to give some insight. But my concern for folks, and this is a classic framing, while it's framed as a legal question, this to me is 95% emotional. And I'm not trying to diminish your emotions or your feelings or your sense of betrayal or whatever it is. It feels to me that this is an emotional question wrapped up in legal jargon. And so I would encourage you to work through whatever the emotional issues are. I doubt it will have a legal impact, but if you're holding on to it, or you're holding on hope that the legal system is going to resolve that, now you're expending a whole lot of energy. I had a call yesterday with a client, a legal client, slightly different context, but man, the legal system is failing them and failing them and failing them. And I feel their pain. And when I first met with them in their home, and this is a dispute with a neighbor, and I mean, it's now got yet another lawsuit. I mean, we have multiple lawsuits going. They are just fighting, and both sides are digging in their heels. And there's hurt. My clients are hurting. And there's little or nothing I can do as a lawyer. And I'm more empathetic than I used to be. But they want the law, like, do something. Can't you do something? And I said, no. Well, I could. Some lawyers, of course I can do something. I'm going to file another lawsuit. $100,000 later, the outcome's the same. I didn't get any relief. Even if I get a judgment, the neighbor's not moving, and the neighbor is going to keep doing whatever the neighbor's going to do. And so it's just the limits of what the legal system can do. And I feel for them. My integrity says, I'm going to tell you if I don't think the legal system will work for you. And I'm not just going to take your money and go file lawsuits. Other lawyers, I mean, you can always find a lawyer who'll take your case. There's always somebody out there who'll take the case. And so that's why I caution, guard against it. And if it's truly emotional, spend the money on treatment, therapy.
Next question. What is suggested when only one party wants a divorce? Is this a contested divorce?
Depends. From a legal standpoint, it depends. Yeah, one party may only want it, but once a divorce is filed, it's a two-party case, and both sides need to decide how they want to handle it. It's not, again, the who wants it is a clinical issue in my view. And basically what I think you're saying is one person has arrived at that point and one person hasn't. That doesn't mean the other one isn't going to get there. The question is, how do we best get there? How do we best get to the same place? What's the most efficient and effective way? And what I would suggest is work on the clinical side. What's really going on? Can you get both people aligned? Because if you can both be aligned, then yeah, you can do a family law mediator. You can agree on a bunch of stuff. The legal process is going to be so much more efficient and effective if you can agree. But if one person just unilaterally files and the other person is blindsided, well, maybe that's part of the problem in a relationship, because how can you be blindsided that one person is so unhappy that they're filing for divorce and you didn't even know? That's a whole nother set of issues that hopefully can be worked on. But unilateral action when you're in a bilateral relationship, rarely if ever effective. You have the right to do it. Anybody can go file for divorce. You don't need someone's permission or consent to file for divorce. And you don't even need someone's consent or permission to get a divorce. The court will order a divorce eventually. But man, it's going to be expensive, and it's going to be unsatisfactory. It's even if you divide the property, that's not the issue. The issue is also the grieving and the loss of a relationship. Beyond the betrayal, it's the grieving and loss of a relationship that you have invested so much into. Could be financially, but emotionally. The loss of, you thought this was the one. And so there's a whole lot of work that you can do for yourself. Hopefully the spouse or partner will do it as well to get there.
Okay, the next question. I'm finding a wide range of consultation fees. In your experience, do you see a direct correlation in an attorney's value and the rate they charge for consultation fee? I'm in the position of having no access to our finances, and I don't want to have a lesser representation just because I have to seek out free or lower cost consults.
Another great question. So I think there is some correlation between rates and values. Generally, most lawyers, the more experience you have, the higher your rate is. And generally, the more experience you have, the more effective you can be. I think there is diminishing returns. Here's what I would say. I know my own experience as a lawyer. So I've been doing this 31 years in the state of California. And after maybe I went out on my own after 11 years. So I've been practicing as an independent for 20 years. The moment I went out on my own, my rate probably got cut in half because I'm not paying big law rates. So I would say and family lawyers often are sole practitioners or small practices. So you're not paying big law, these huge law firms with massive offices and all the staff. You're not paying their rates. And I also think experientially, some lawyers just think I need to add $10 or $20 or $50 every year of my experience because I'm worth more. After 10 years, 15 years, 20 years, I mean, how much is a lawyer worth? So I do think there's a rule of thumb. I wouldn't necessarily go to the cheapest or the lowest cost provider, but you certainly don't need the highest or most expensive. And I would also say, if in doubt, I would try to summon the resources to find the person that you think is the best fit. And I would encourage fit, really, really important when you're working with a lawyer. So if you do a 1-hour consultation, does this feel, and I'm using that intentionally, not just, they may be the leading expert in the field, But if your experience of them is not good, or if your experience of them is, okay, well, here's my associate who's really going to handle your case, or here's the paralegal or the secretary, you'll never have access to the lawyer. The lawyer isn't empathetic. The lawyer doesn't listen. The lawyer knows better than you. Whatever it is, that's not a good fit. And I don't care how good the reputation is or how expert they are. I would not hire them. I want to hire someone that is a good fit, that I can trust, that I can bond with, that I feel has my best interest at heart, who can have tough conversations with me, who can confront me if needed, but that I feel respected and valued, and I feel that I have a connection with them. And so I think that is as important, assuming they meet the minimum level of criteria for being competent. That's a really good thing, and I would focus on that fit question.
Okay, and then the next question is, what is the benefit of doing a legal separation as opposed to just a separation?
I'm not sure that there's a legal distinction there. At least in California, there is a date of separation that sometimes you know it and sometimes you don't. So I'm not quite sure what you're getting at. Again,
so because I've heard of like legal where there's legal paperwork filed for separation versus, hey, we're just going to separate. I'm going to go live in a different house. That to me is sort of a distinction.
So it really, again, it depends, and I would check in the jurisdiction. So often the date of separation isn't necessarily known. Like, we didn't realize that this is actually what it was going to be. I think, and in some jurisdictions, and it's jurisdiction dependent, if you're taking let's say a hiatus, we need to be apart for 30 days, but the intent is always to come together. There's no intent to end the relationship, at least at the time. And we're just going to live separately for 30 days. That initial date that you left is probably not the date of separation, or may not be. On the other hand, it's like, I'm moving out, I'm done. Even if you don't file for divorce, I'm going into an apartment. That date of separation probably becomes the quote unquote legal date of separation, because that's when you made the decision to end the relationship. So the significance is, at what point is the relationship over? It's not necessarily over the date that the divorce decree is signed and finalized and entered. We often look at what was the date of separation. So I would look less at the terminology, because it may be different in different jurisdictions. I would look at what's the intent, and at least in your jurisdiction, it's essentially, what is the cutoff date for this relationship? It's particularly important in community property states if the relationship is over. The support may be different, or the allocation of resources may be different.
Well, and I could also see like having a timestamp, because if the assets are different and now the assets start to change, for a variety of reasons, you would want to have some known, from that standpoint. So,
right. I mean, at least in California, you have to have a date, but sometimes it's even negotiated depending on what's going on.
Okay. Well, this has been really helpful from an it depends standpoint. So no, hopefully this has been useful for those of you joining us. The video will be posted on our website. I put the link in the chat, but you can find it on the Seeking Integrity website. And Stuart, thank you so much for joining. I really do appreciate I took notes. I've got more information, so it's helpful for me from my standpoint as well. So I'm grateful for your time today.
Thank you, everyone.